It's time for Preserving Your Dignity and Your Money, Planning for Successful Aging with Nugen Law. And now your host, J. Bryan Nugen, estate planning and elder law attorney.
Good morning and welcome to Preserving Your Dignity and Your Money, Planning for Successful Aging with Nugen Law. I'm attorney J. Bryan Nugen, founder of Nugen Law and your host for our program. The purpose of our show is to have weekly, in-depth conversations about matters relevant to folks as they walk down the path of successful aging. Our listeners will learn what it is to age with dignity and how best to protect their money. I've been practicing law for 3 decades. I'm licensed to practice in Indiana, Ohio, Michigan, and Florida, and actively represent clients in all 4 states. My practice, the attorneys, and our interdisciplinary team of professionals who practice with me concentrate on working with clients in estate planning and elder law and areas related to them, such as estate and trust administration, guardianships, planning for those with special needs. Today's guest is Jesslyn Smith, an attorney with Nugen Law. Jesslyn is licensed to practice law in Indiana, has been doing so in excess of a decade, is currently serving as president of Indiana's chapter of the National Academy of Elder Law Attorneys. Welcome, Jesslyn Smith. Great having you on.
Thank you. I'm excited.
Good. Great. Jesslyn, as president of Indiana's chapter of the National Academy of Elder Law Attorneys, there is no one better for me to ask this question of. Our listeners have heard people talking about estate planning attorneys and elder law attorneys. It can be confusing. So, what is estate planning? What is an estate planning attorney? What is elder law? What is an elder law attorney? Are they different? How do they relate? Let's talk about that.
Okay, yeah. So estate planning is, or what I tell clients is that it's getting those documents and instruments in place to tell people who you want in charge and what it is you want done with your assets when something happens to you. So it's establishing how you want the things you've worked hard for to go when you're gone.
So when you pass.
Or when you pass.
Right. So estate planning I think of as I'm planning now to handle matters at the time of my passing, not necessarily during my lifetime, but when I pass. Are we going through probate? Are we not going through probate? Do we have an estate that's taxable? Is the estate not taxable? And then let's have that same discussion about elder law, which is a little more confusing. What's elder law?
So I tell clients that elder law is looking at when someone has a disability or a condition or some kind of life event that has happened that causes some kind of incompetency or disability, and now we need to look at how do we care for this person but also protect their funds so that they don't go bankrupt.
Mm-hmm. Yeah, that's fair. I think that that when we're talking about clients that have a disability or some cognitive issues, that is definitely part of elder law. But we may also be working with clients before they get to that point, and that we're thinking in advance. How do we protect assets during our lifetime so we can get benefits during our lifetime and preserve and protect what we spend a lifetime garnering, our IRAs and our real estate, etc. And then it dovetails into estate planning. So that elder law work, when we're protecting their assets and we're assisting them to age successfully, it may also involve passing along their estate at the time of their passing. That's kind of where they meet and dovetail.
Yeah, absolutely. They cross paths when we look at trying to protect those assets while they're still alive.
Sure. So are there milestones, ages, or life events you normally see when people are seeking your advice for estate planning or elder law?
Yeah, a lot of times I do see clients start to really think about it when they hit retirement age. Mm-hmm. That's the biggest one. And then the second biggest is usually when there's been an accident or a disability or someone's got a diagnosis from the doctor, then they start thinking we need to start doing something now.
Sure. for estate planning, I always, it seems to me I'll have clients that are young that really haven't started garnering wealth, but they have a newborn baby, right? It's their first child, and they're thinking, oh my gosh, who's going to, raise our child if we're unable to do so, if tragedy strikes? So I oftentimes when folks have their first child that they may come in and do some basic estate planning. I like to call that legacy care planning. And then, as you're saying, Jesslyn, I think it's true that the next major step is people are thinking about retiring. They're in the process of retiring, or they've just retired, and they're adulting, right? They're recognizing I better get these things in order, and seems to me this is the time to have those things in place.
I think another really good time for folks to look at it too is when someone's actually turned 18 or when they're getting ready to go to college too. A lot of folks don't stop to think about those events and things that happen. You're off at college, your parents may need to be helping you take care of paying any bills or things like that while you're busy, going to school. But once you turn 18, you are an adult and only you can act for yourself unless you have the right documents in place. Sure.
I also find it when, and you alluded to this earlier, when there's a major life event, right? We have a spouse that's died, or a spouse that's been diagnosed with an illness, a disease, a condition that was unexpected, and there's kind of a panic that goes through the family. So they're coming in to talk to us. They're nervous. They've heard horror stories about losing wealth or not having things in order. So I think major life events like that also happen, death of a loved one, in illness, etc.
Yeah.
So when first meeting your new estate planning and elder law clients, what types of things should they be thinking about even before your initial meeting? So our listeners that are listening to you today thinking, gosh, I need to visit Jesslyn and see what this is about. What is it that they should be thinking about in advance of their coming in to speak with you one-on-one?
Yeah, I think they should be thinking about what is important to them. What is it that they have, and who is it they want those important things to them to go to, and who do they want in charge? Mm-hmm. Think about, who do I trust, and who would I want helping make those decisions for me? Because you're ultimately going to be putting somebody in place that's supposed to take care of the things you would take care of for yourself.
And you could, for example, one person may be great with money, but could never, would buckle in the minute of stress if we're dealing with healthcare decisions. So you can appoint one person to fulfill one capacity, one decision-making capacity for you, and you could plug someone else in to make different decisions for you, both as you age and at the time of your passing.
Yeah, absolutely. And I have that conversation with the clients that's important to think about, because one person in your family may be more financially stable or understand the financial lingo and terms. So that's who you want in that place. And then you may have someone else in the family that is a nurse or a doctor or is in the medical field. They're going to understand what it is those doctors and physicians are telling you in those moments of time in which you need someone to help you make those decisions.
Sure. I think with the age of the internet and information is so readily available, we'll have clients that are reading before they come in, and they kind of have a preconceived notion of what they do or don't need. And I always prefer them to come in as a blank slate, and we just talk about what is it that you want to get accomplished. Let's forget the legal mumbo jumbo. What is it that you want to get accomplished? What is it that what goals do you have for yourself, for your family members? And as you said, who are those people that you're going to put in decision-making positions if need be? Those are the things that we want them to think about. Is there other information or documents that your client should bring to their initial meeting with you?
Yeah, usually I like for them to establish a baseline of what it is that they have, whether it's putting it out on a spreadsheet and just having kind of a basic idea of what it is they own, because depending on how much they have may determine what we may recommend for the right tool for them to have in their situation. And so having that idea of what it is they've got really helps us in establishing what is their best options.
Mm-hmm. Mm-hmm. Yeah, I when I'm meeting with my clients, sometimes they're hyper-focused on a balance in a checking account or a balance in a savings account or exactly how much they have in their IRA. The exact balance isn't necessarily that important to us. It's really, generally, how are your assets invested? Right? And generally, how much do you have in those assets or in those investments? And from an attorney standpoint, I may be able to handle an IRA in a particular way, but I'm going to handle a brokerage account in another way. We may handle liquid monies that like checking accounts and savings accounts in a third way. So it's really more about what types of assets they have, what types of investment tools that they're using, and then generally balances in those accounts. But I don't necessarily need to have sometimes there are appointments where I need to have the exact statement, but typically it's a general idea of what they have, where it is, and people forget assets. Oh, I have bonds. I forgot I had bonds. Oh, I did buy those CDs some years ago. I have a life insurance policy that my parents bought for me that I've been maintaining for all of these years. I don't even know if it's worth keeping anymore. Yeah. So to really be aware of who it is that's making decisions for you or you want to have making decisions for you, and generally your assets and what you want to get accomplished.
Yeah, absolutely. I think just having that baseline idea of what it is you have really sets the tone then for us to make the best recommendations.
So what are you focusing on when you're meeting your new clients?
Well, I always like to start the meeting off asking the clients what is their goals and what questions do they have, and then from there, I like to focus on, well, here's the different options and tools that we have. And I go through those, and then I tell them, based on what you are telling me your goals are, this is what I recommend is the best fit for you.
Sure. Yeah, I will oftentimes say in my client appointments, you're driving the bus, right? I'm giving you the information, but you are definitely in charge. At no point am I telling you what is or isn't going to happen. My job, I'm an educator. I feel like I'm giving them the education about what options that they have, what we believe or what I believe is most appropriate for them. But ultimately, they have to be happy with their decision. And sometimes I may respectfully disagree. And so long as it isn't a horrible situation they're creating or a real pickle that they're putting themselves in, of course, we would always respect what it is that the client wants in the end. What do you want to achieve for your clients after you've met with them? They've let you know what their goals are. What is it that you want to achieve for them?
I want to achieve preparing those documents for them the way that they want them and making sure they meet those goals. And then making sure that I sit down with them and go through them and make sure they understand what those documents are saying and what they are doing. So my goal is to make sure we put in place for them their wishes.
All right. So you've mentioned preparing different things. So let's get into that just a minute. There are lots of different types of instruments we discuss with our clients. Let's educate our listeners about what they are and what each achieves for their benefit. I want to start with durable power of attorney. I shouldn't even say durable. I should just say power of attorney. There are durable and non-durable powers of attorney. So what is a power of attorney and what does it permit the holder of that POA to do?
So the power of attorney document is a legal instrument that names someone to help you handle matters for you. And there are different types, but most commonly it's a durable financial power of attorney. And it puts someone in place to help make those financial decisions and handle financial matters for you. And the durable part of it means that it survives any disability, incompetency, or lapse of time that may actually happen to you. So, and it also means that you're still able to handle and manage your finances while you're alive and able to. It just has someone in place that can step into that role when you're ready for them to do that.
So I'm going to mention this. Just yesterday, I had a client in that another attorney had prepared years ago. I don't even think they're practicing any longer, but years ago had prepared a springing power of attorney. And I'm not a big fan of springing POAs, but let's talk about that. What does it mean if a power of attorney is springing?
So springing means there's some kind of event or trigger that then makes the document effective. A lot of times you'll see it'll say that I've become incompetent or disabled, and a physician has certified that in writing. So usually you have to go get a doctor's letter or two, which can be difficult, especially if you're only seeing one physician. And then if you need two physician letters, then you've got to look on trying to get that individual in front of another doctor to even get the document to be able to work.
Well, and I think it creates a delay, an unnecessary delay. And when clients are hesitant to sign a power of attorney, they feel that they're giving too much power to someone and they're not sure what they're going to do. My response to that is, you're not picking the right person.
Absolutely.
If you feel that a person is going to take advantage of you financially by signing that power of attorney, and you have a client that's encouraging you to have a springing power of attorney, I only want it in effect when I'm incompetent. It doesn't make sense to me. If you don't trust them with being appointed as your attorney in fact under that power of attorney, why in the world would you trust them at the point in time you become incompetent?
Yeah, I absolutely agree with you on that.
Sure. And the springing, to your earlier point, Jesslyn, if I have to reach out to doctors and get letters, we're delaying the entire process. And we don't want that. We want it that we can use it right now. It's effective immediately. And that to me makes most sense for our clients. I think a durable power of attorney is essential to our clients to have in place. From, as you mentioned earlier, from students going off to college to folks in their 90s and beyond. So what may happen to someone if they don't have a power of attorney in place and they become incompetent? Then what's the process?
Then we have to look at guardianship, which is more costly, and then you've got the court involved in your business because there are requirements on reporting. So now the court knows your assets and all of that. So it's not as personal and as private as if you had a power of attorney document in place.
Mm-hmm. And you have a thriving practice with guardianships, but it's always preferable if you are able to appoint someone during a time that you are competent to make those financial decisions on your behalf. It's always preferable.
Yeah, absolutely. Yeah. I would much rather do that now ahead of time so that, again, there's also a delay sometimes in the court process because we have to go to a hearing and everything. And so it can then delay us in being effective and getting things done for you.
So before we move to the next topic, I do like to let my clients know the person that's appointed you, that they've signed the power of attorney. So the document is the durable power of attorney. You are not their power of attorney. That's the document. Your position is agent or is attorney in fact. So you would be signing as the attorney in fact under the authority of the power of attorney. All right. So the next instrument people often overlook is a healthcare representative designation. if you would, Jesslyn, please explain what it is, why it's important, and how the law has changed with these over the past several years.
Yeah, so with the healthcare representative designation, it is naming someone to be able to make healthcare decisions for you. And with that, how it's changed is it used to be under the power of attorney statute, and it was a healthcare power of attorney document. But within the last few years, that law has changed, and they've moved it into the healthcare statutes, and now it's a healthcare representative designation. And so with those healthcare representative designations, you name someone to make decisions for you when a doctor says that you're unable to make your own healthcare decisions. So they're not effective immediately. As long as you're still able to make those decisions for yourself, the doctor is always going to ask you what your wishes are. But it puts that person in place to make the decision if you can't communicate those wishes and desires to your doctor.
I think that's an important distinction between the power of attorney we were just talking about and the healthcare representative designation. That POA, ideally, at least in our opinion, is effective immediately, whereas the healthcare representative designation, you are still in charge of your own destiny 100%. The person that you've appointed, that designee, has no decision-making authority and can't weigh in unless you are, in fact, incompetent, incapacitated, unable to make decisions on your own behalf. I think that's important, especially when we're dealing with senior clients that are very sensitive to having concerns about someone forcing them out of their home or forcing decisions upon them. And so they get a little nervous about signing that. And I always like to point out to them that this is only in effect when you no longer are able to make those decisions. The doctors will always respect your decision first, without a doubt. Living wills. So living wills have been able to be become part of that healthcare representative designation. That's a recent change in the law in relationship to that. So let's talk about what a living will is and how that feathers into that healthcare rep.
Yeah, a living will is an instrument in which you designate what your wishes are if you want nutrition or hydration, if you're in an end-of-life situation. There's 3 triggers that the doctor has to usually certify. He has to certify that you have an incurable injury or disease, that he believes you would pass away in a short period of time, and that any care they would give you would just prolong that dying process. Mm-hmm. And if a doctor certifies that, you can state, do you want nutrition and hydration, or do you not want nutrition or hydration, or do you want to leave it up to a healthcare representative designation that you've made?
Sure. So between you and I, how often is it you're finding clients say to you, keep me alive in a persistent vegetative state, I want to be prolonged inevitably?
It's a very small percentage. I would say maybe 10 to 15% at most, usually, but it's probably even smaller.
In my career, I've had one person ask for that.
Yeah.
It most consistently, people are saying, if the effort to sustain my life is futile, if I'm actively passing, I do not want to be kept alive in a vegetative state. And if people have experienced what that's like, what it looks like, and to see their loved ones go through that, it most definitely affects their opinion in what they're making decisions about in regard to the living will. Okay, so I also like our clients to have in place something called a HIPAA waiver. HIPAA stands for Health Insurance Portability and Accountability Act. It allows the designated person to access one's health information, records, etc. It's difficult for someone to assist in helping to make decisions about your medical care if they can't see your records. So people are familiar with these when they go to the hospital or they have a blood draw, or normally you're signing a HIPAA waiver at that time so that the hospital can speak to your insurance company and can disclose information about the treatment that you received so that you can be reimbursed or have the insurance company pay.
I think it's a good tool for us to bring up to clients and prepare for the clients, because hospitals are different in the documents that they have and the forms that they have for it. And this is a standard form that the entire medical community can use for you. And so I think it helps kind of standardize that so that they're not having to worry about signing a new HIPAA waiver for every single medical need that they have.
So that healthcare representative designation you mentioned a few minutes ago, it actually permits access to medical records. But what I found is, to your point, Jesslyn, doctors' offices, hospitals are used to seeing that separate standardized form. So if we have that, we don't have a delay in needing to educate the physician, having to educate the hospital. Oh, no, the healthcare rep is the same thing. It's good. No, I like to have that separate standalone HIPAA.
Yes.
Now, for the document most people think of when they think about estate planning, last will and testament. So I oftentimes have people during our first meetings, just as I'm sitting down, say, all I need is a simple will. That may be the case, or they may need something else. I encourage them to allow me to speak with them, get to know them, and learn about their goals, and then allow me to make some recommendations for them to consider. Our client is always in charge. They make the final decision, but I want to make sure that's the best informed decision for them to achieve their goals. I want and enjoy for them to use my training, my education experience to reach their goals and what they want to have for their family and themselves. Jesslyn, what is a last will and testament, and what's the purpose of the will?
Yeah, so the last will and testament is establishing who you want in charge after you pass, and what do you want that person in charge to do with your assets, and who does it go to? Mm-hmm. So who is that personal representative supposed to distribute those assets to?
Mm-hmm. So when a person has a will and they pass away with assets in their name, they're required to go through probate, right? So, or estate administration. So please explain what probate is. We throw that word around. We're so used to probate. We're used to estate administration, and I can use that word in my meetings with my clients, but sometimes they look at me a little, perplexed. What is that? So, Jesslyn, what is probate? What's that process?
So probate is simply meaning that you have to go to the court in order to be appointed as the personal representative, and then under the estate administration or the probate, then you are able to distribute the assets either according to that will, or if there wasn't a will, then looking to the intestate statute, which is the statute that says who it goes to if you didn't have a will in place.
Okay. And that estate administration probate process, I see taking 6-12 months and longer, and is frankly a little more expensive.
Yes, absolutely.
Yeah. So let's not forget, though, about one of my favorite estate planning tools, and that's the trust. When I mention use of trust to clients, they can become a little nervous. So they're concerned if their estate is large enough to merit having one. How do they manage a trust? Is it going to be expensive? The term trust covers a very large umbrella of instruments, but for today, when you and I are talking, Jesslyn, I want you to talk about a living trust. What is a living trust, and why is it used?
Yeah, a living trust simply means that while you are still alive, you can amend or change that trust, which means you can change who you've appointed as the trustee, who's in charge after you pass, or you can change who the beneficiaries are. You can add assets. You can take assets out of the trust. So you still have control. I kind of like to refer to the revocable living trust as being an umbrella. It's an umbrella over you that holds the assets for you.
I think of it as like it's a giant beneficiary designation. And so just like you might have a beneficiary you designate on an IRA or a 401k at work, and it goes to them automatically at one's death, The trust accomplishes that as well. It skips the probate process, avoids that expense, and allows those assets to go out to the intended recipient at the time of one's death.
Well, and it also makes it private then. Whereas if you're filing that probate estate with the court, your information again is open to the public, and so a trust allows for that personal information to be private.
Thank you, Jesslyn, for joining me and our listeners today. You've provided some invaluable insight. If someone would like to meet Jesslyn in person to discuss estate planning or another elder law matter, I encourage you to call us at 260-925-3738 or email us at help@nugenlaw.com. Thank you for listening to Life Care Planning with Nugen Law, and to our guest, Mrs. Jesslyn Smith. I look forward to next weekend, Saturday at 9 a.m. for Life Care Planning with Nugen Law.
You've been listening to Preserving Your Dignity and Your Money, Planning for Successful Aging with Nugen Law. For more information, log on to nugenlaw.com or email help@nugenlaw.com. Nothing stated in today's program should be considered as legal advice, should not be considered as having created an attorney-client relationship between show host and guests and any listener. Nugen Law is not liable for anything that happens as a result of a listener relying on provided information as legal advice. The content is for informational purposes only.